Hi, good afternoon, everyone. We're going to get started on the webinar. So this is Estate and Medicaid Planning Myths, and I'm J. Marie Schaeffer. I'm a partner at the Herzog Law Firm, and I welcome you to the webinar. Hope you enjoy it. So to start, we're going to talk about what is new as a result of COVID-19 and how that's affected our law firm. As it's affected everyone else, we are keeping our social distancing. However, our law firm is still open. So what that means is that we are working remotely for the majority of us. We do have staff in the office every day so that we can take your calls, check your mail, check our mail that you send to us, and pretty much do everything that we can do normally. We're operating basically at full speed. We are continuing to do phone consultations. We're also doing video consultations with clients. We're exchanging documents with clients by email. And we're all becoming experts on video conferencing like this, like Zoom. Another new development that's happened is that we are doing our document signings now, either by video conference, where we watch you sign the documents, and then you send them back to us, and we can notarize them or witness them. And that's perfectly legal. Because of the social distancing, one of the orders that came out from Governor Cuomo was that we can notarize documents remotely, and we can witness wills and healthcare proxies and powers of attorneys remotely. So that's great, allows us to keep doing business as usual. For people who aren't so good with videos or they're not comfortable doing a video signing, we are making accommodations to meet them downstairs in the parking lot. And we give you the papers to sign, and then we step back and watch you sign them, and then you give them back to us, and then we can witness them. So we're being very creative. We're coming up with new ways to make sure everything gets done every day as we learn to adapt to this, as I'm sure all of you are. We are still doing Medicaid applications. We're still doing our estate administration work as much as we can. We're working around the fact that the courts are closed, but the courts are open still for any emergencies. So an emergency guardianship, an emergency that comes up in a probate. So we can handle all of these. And we're as busy as ever. Now is an important time for everyone to think about your estate planning documents. Do you have the healthcare proxy and the power of attorney? If you don't, should you get one? Do you know what they are and why you should have them? We're going to get to that a little bit when we talk about some of the myths. You should have a will. If your will and your other documents are old, you probably want to take them out and look at them and see if they need to be updated. So maybe your agents have moved or they're not able to do it anymore, and you want to appoint someone new. So all of these different things are keeping us busy, and we are here to help you. So if you want to update your documents or look at your documents or talk to us for the first time, you can call our office, you can email us, you can set up an appointment with Stacy, and she'll set up an appointment with any one of the attorneys. And Stacy is our scheduling coordinator, for those of you who don't know. And our number is 518-465-7581, or you can email info@herzoglaw.com. So before I go on, I just forgot to mention this at the beginning. There is a chat box that you can see on your screen. And in the chat box, you can type in your questions. And we're going to answer those questions. We've reserved 5 minutes at the end to go through those and answer your questions. So feel free to ask your questions anytime during the presentation. So next thing we're going to talk about is Medicaid changes. So it's not enough that we have a pandemic to deal with, and we have to learn new ways to operate as a law firm and get our work done. We also had new Medicaid changes that were passed in the recent budget, and they are affecting all of our clients, and we're here to talk about this with you. So to start, let's talk about a little bit of the background of the Medicaid changes. New York State, as many of you know, was facing a deficit, and mainly it was because of Medicaid. So the governor decided that we needed to find a way to cut dollars from the Medicaid budget. So he appointed a Medicaid redesign team to come up with Medicaid savings. Now, this was done about 9 years ago, was the last time they did this, and they came up with a lot of changes. One of the big changes was that the Medicaid program, at least, well, for both nursing home and home care, the management of that in general switched over to manage long-term care companies. So that was one big change that took a lot of getting used to. But this time, the change is really affecting individuals more. That was kind of more at the provider level. And this time, they are changing one of the main ways that people qualify for community Medicaid. However, the good news with these cuts is that they can't be put into effect right away. The changes were passed and included in the budget right at the last minute, right before April 3rd when it was finalized. However, at that same time was the time that the state had to decide whether they wanted to accept federal emergency Medicaid funding from the federal government. And at first, I think the governor wasn't so sure he was going to take it, but then he decided to take it, of course, because the state needed the money. And one of the provisions of accepting the emergency funding was that the state could not make any cuts to its Medicaid program while they were receiving this funding. So currently, they can't put these changes into place. Some of them have an effective date of October 1st. Some of them go out even further. And hopefully by that time, we will not be in the situation where it's an emergency anymore. But if we still are in an emergency situation, they left power to the governor to extend the beginning date of these Medicaid cuts. So here's one of the biggest changes that is going to affect most people, and that's that there is going to be a change for community Medicaid applications. They are going to start imposing a 30-month look-back period on community Medicaid starting on October 1st, 2020. So let's put that in perspective. So as many of you are aware of, and you've probably heard the rule about the 5 years and the 5-year look-back, and what does that mean? And that's been the rule since 2006, that if you are going to transfer assets and set up a trust, it has to be done 5 years before you need to go in a nursing home. And that's been that rule. Prior to 2006, it was a 3-year rule. So around that time, when it switched from the 3 years to the 5 years, we were really busy because we were trying to get clients in under the old 3-year rule before it switched to the 5-year rule. But all along, this has only been for nursing home. There's another aspect of Medicaid that's called community Medicaid. Community Medicaid lets you receive care in your home. So it lets you have home health aides come into your house to take care of you. It provides adult daycare. It provides medical transportation. It provides a whole host of services that are meant to keep you out of the nursing home and at home. Now, up to now, and continuing right now, the 30-month, there's no 30-month look-back period. So you could transfer your assets, you could set up a trust, and you could be eligible for community Medicaid right away. So for example, if I had $200,000 this month, and I knew that I needed some help at home and I wanted to apply for community Medicaid to help me, I could set up a trust, I could fund the trust, and next month, in May, I would be eligible for community Medicaid. There's no look-back period, no 5-year look-back period, no 3-year look-back period, nothing. The change now is that starting in October, you have to wait 30 months before you can become eligible for community Medicaid. So that's 2.5 years. So you have to plan in advance if you are going to apply for community Medicaid. So we're kind of used to planning in advance on the nursing home side, where we know there's a 5-year look-back period that we're working with, but we kind of always had that fallback, that safety, You know, even if you set up a trust and let's say you don't get through the 5 years before you need some help, you always had the option of applying for community Medicaid and getting care at home while you were waiting for that 5-year period to run out. Now, however, that's not going to work because now it has to be done 2 years in advance. This is going to be a tremendous change because there are going to be people who need care and they need it right away and they have it planned in advance. So that's going to cut out their opportunity for community Medicaid. Because if you've transferred money, you have a penalty period that's applied for transferring the money. So you may be in a situation where you gave money away, you need help at home, but because you gave money away in the past 30 months, you're not going to be eligible and you're going to have to wait or pay out of your own pocket. Now, this isn't just for trusts. Any gifts of money that you make, you're going to be penalized for community Medicaid. So, for example, if you gave money to your grandchild for college, that's a common example. Let's say you gave them $10,000 last year, and now you need Medicaid. Even though you weren't thinking about Medicaid when you made that gift, Medicaid's going to see that gift, and they're going to say, well, because you gave about $10,000 away, we're going to penalize you for 1 month. Now, what are you going to do? Are you going to go back to your grandchild and get the money back? No, because they spent it on college. So now you're in a situation there. In that type of a situation, there is a possibility that you can argue that this was a gift other than for Medicaid purposes. Now that's an exception to the rules and you have to go to an appeal to argue that. So there are some ways around that. But in general, all the gifts you made to your children, to your grandchildren, to anyone is going to count and prevent you from getting Medicaid if it was done recently. So that's kind of the biggest Medicaid change that's going to affect people. And because of that, if you were thinking about doing an irrevocable trust to protect your assets, now is the time to do it. Because we have this little grace period here, we have until October 1st when we know the law will change. You can get in, you can get your irrevocable trust done now, so hopefully this law is not going to apply to you in the future. So that's something to think about if you have been thinking about an irrevocable trust. If you don't know what an irrevocable trust does, we'll talk about that a little bit, but basically an irrevocable trust protects your assets for Medicaid as long as it's done in advance. So if you transfer your assets out of your name into a trust where someone else is the trustee and you give up control over those assets are going to be protected. They're going to be protected once you've gone through the waiting period. So that's one of the changes that's really big that's coming down with the Medicaid. There's some other changes that are also coming with Medicaid. They have to do with the evaluation to see if you're eligible for Medicaid, what kind of, really that comes down to how many hours of care you're going to get and how they assess you for that. So that's kind of a big change. There are some changes in people who need a lot of care, over 12 hours of care per day, that they're going to get some additional scrutiny to see that they need the care and that they can stay at home safely. So some of these changes are affecting your eligibility for how many hours of care you're going to receive, and that's kind of more at the level where you're meeting with a social worker and you're deciding, how many hours of care and how can I get more hours of care, and does a doctor need to certify what I'm doing? And we're not going to get into detail on those today. We can do that at a later webinar. There's always just so much material to talk about that we can't get it all in one time. So today, I think your takeaway is the 30-month look-back period for community Medicaid, and know that there are other changes out there. So now that we talked a bit about those new Medicaid changes, we're going to go through some state and Medicaid planning myths, because there's a lot of misinformation out there. Common conceptions, we hear it all the time when we meet with clients, when they call us, when they call into the radio, and we just want to debunk some of these myths. We want to bust them. I put myths busted up here. If any of you know, if you have kids like I do, you probably know the Mythbuster show. That was a really popular show when my kids were young. So we're going to go through and bust all these state and Medicaid planning myths. And these are some of the ones we're going to talk about. So let's get started. So the first estate planning myth that we hear frequently is someone is ill, right? Someone is sick, and they say, I don't need a healthcare proxy or power of attorney because my family can do things for me. Oh, that's not true. Because if you don't have a healthcare proxy or a power of attorney, there are many, many things that your family cannot do for you. And if you don't have one and you're not able to sign one because you're incapacitated, your family is going to have to go to court to have a guardian appointed for you. And that's very costly, very timely, something you can avoid. So, you know, you're a married couple, right? You think, my spouse can do anything for me. Well, there's certain things that your spouse can do legally. If you're joint on a bank account, you can pay bills out of that account. But what if you have to sign a legal document for your spouse? You can't do that without a power of attorney. As an example, my husband and I, a few years ago, did a refinance on our house. And my husband couldn't get away from work, I should say, to go to the closing. So I couldn't sign for him, so he gave me a power of attorney and I signed his name on all the papers. So things like that you can't do without a power of attorney, even if you are married. And this can become very obvious in a situation where you're sick or you're ill or you're in the hospital, because you're going to be asked to sign an admission agreement, to a nursing home. You may have to contact your health insurance company to talk about coverage. And if any of you have ever tried to call an insurance company and get information on your spouse, they're not going to talk to you. They're not going to give you any information. So you need to have that power of attorney to be able to fax to the insurance company to get information. Another thing that you can't do if you don't have a power of attorney is do any Medicaid planning, which we're going to be talking about. If you want to set up a trust, if you want to apply for Medicaid, you need to have a power of attorney to do any of those. So it's really important to have these documents. You may be married, you may have adult children who do help you and do certain things for you, but they can't do everything for you without a power of attorney and without a healthcare proxy. So the next myth that we're going to talk about that we hear pretty frequently is, I don't need a will because everything will go to my spouse. Well, that is in some cases true, but not in every case true, right? Everyone should really sit down with an estate planning lawyer, an elder lawyer, and look at all of your assets. And we can look at them and tell you what is going to go to your spouse, what's not going to go to your spouse, and why a will would help you. And here are some of the reasons why you do need a will and why it is going to help you out. So first of all, if you have joint accounts, yes, they're going to go to whoever is joint on that bank account with you. If you have accounts with beneficiaries, they're going to go to the beneficiary. But if you have any assets in your individual name, they can't be, no one can access them after your death. If you don't have a will, there's something called the intestacy law in New York. And that's going to apply to assets that are individual that you don't have any beneficiaries on. So for example, if you're married and you have children, I bet you would think it all goes to your spouse. However, the intestacy law says that half goes to your spouse, plus an extra $50,000, that's a little cushion, and then 50% goes to your children. So that's not what most people would want to happen. Most people would want their spouse to get all the money to live on if the first spouse were to die, and it's only after the second spouse's death that it goes to the children. So the intestacy law isn't going to match what most people want happening. So the easiest way to get around that is to do a will, And it could be a very simple will. It can say, I leave everything to my spouse, and if my spouse dies before me, it goes to my children. So that very simple basic will is going to switch things around and get it all to your spouse, which is, probably what you would want. You can do anything you want in the will. It doesn't have to go all to your spouse and your children. You can leave it in different ways. You can leave it in trust. However, I should go back up on that. If you are married, you can't cut your spouse out, okay? There's something called the right of election in New York that says that if you're married, you can't cut your spouse out of your will. Your spouse has a right to at least 1/3 of your assets. So you could cut them down to 1/3, but you can't cut them out completely. So if you're thinking of that, hopefully you're not. That's the rule on spouses. The other benefit that a will gives you is that you choose who gets to be your executor under your will. So the executor is the person who gathers up all your assets, pays all your debts, gives them to your beneficiaries. If you don't have a will, if you die and you have a spouse, your spouse has priority to be a will. But let's say you have 4 kids, right? Each of them has a right to apply to be the administrator of the estate if you don't have a will. And maybe there's, you wouldn't want that. Maybe there's 1 or 2 kids who you think are terrible with money, and you wouldn't want them to be the administrator. So again, writing a will, naming an executor puts that decision in your hands. You get to choose who the executor is, who you think is best to manage everything. The other thing you can do in a will is, if you have minor beneficiaries, if you're leaving money to children or grandchildren, let's say, without a will, they're going to get those assets when they turn the legal age of majority in New York, which is 18. So I don't know about you, but I have a 20-year-old and an 18-year-old. I had to think for a moment because they keep getting so old. And neither one of them is ready to have money. My younger son is probably going to buy a fancy sports car, and my older son, I don't know, probably travel or something. I can't see them saving it for college. So if you want to make sure that happens and you want to put someone in charge of that money, you need to do a will to set that all up. So if you do a will and you have young kids or grandchildren, you can set up a trust for them. And in that trust, you can say anything. You can be very specific as to what they use the money for. You can be more general. Generally, what most of our clients do is they say that money can be used for their education. It can be used to pay for college. And you pick someone, a trustee, to be in charge of that money. And then you pick an age where they can get the money. So somewhere in our default is about 25 or 30. After they've gotten through college and they've gotten a little bit more maturity, then you can say to the trustee, turn over the money to them now. I think they're old enough that they would know how to handle it. We also, our recommendation is you do it in 2 stages. So you can say, I give half to my child at age 25, and then I give the other half at age 30. So what does that do? That gives them a second chance. So if you give them some of the money when they're 25, and they turn out to be not so smart with that money, and maybe they spend, hopefully not all of it, or they spend a lot of it, they get a second chance when they turn 30. Now, this time, maybe they'll think about it and they'll invest it wisely. So all of these things that you can do with a will, you can't obviously do if you don't have a will. It's going to just go to the children at 18. So just thinking that everything is going to go to your spouse, leaves a lot of things open, okay? So looking at your assets, getting them all in line, and, sometimes it does happen when the first spouse dies that everything goes to the surviving spouse because everything is joint. Everything has a beneficiary on it. That's pretty common. If you bought your house together, that's joint. If your checking account's joint. You probably have an IRA or a retirement account that names your spouse as a beneficiary. So lots of times when the first spouse dies, everything happens automatically. You don't even need to probate the will. It's when the second spouse dies, then you have to have a will to say who gets what and to really direct who gets it. If you, for example, I'm talking a lot about spouses and children, but if you're not married or you don't have kids, the intestacy law becomes even more difficult to work with. Because if you die and you don't have a will and you don't have kids, there's an order of relatives who are set to inherit. It goes to your parents, and then it goes to your siblings, and then it goes to aunts, uncles, cousins. It can get very complicated. And if we're trying to administer your estate in that situation, we have to do some family tree research. And we've had some cases where we have 20 relatives on the mother's side, 10 relatives on the father's side. We can't even locate all of them, so we have to publish in the newspaper. So that's a really difficult situation. So I especially encourage people like in that situation to do a will, or even better, to do a trust, so you can name who you want to get your assets, and we don't have to go to court to deal with that. Okay, so I'm going to go on to our next estate planning myth. Okay, this one we hear a lot. So this is that my revocable trust will protect my assets. And the bottom line is that it doesn't. And I think the reason is it's if you're not a lawyer, right, it's difficult to know what's the difference between a revocable trust and an irrevocable trust. I mean, they even sound alike. It's hard to say them and distinguish them. So a revocable trust doesn't protect your assets. People mainly do that to avoid probate or to manage their assets, to set up a trustee to take over control of their assets. There's different reasons why you do a revocable trust, but you're not doing it to protect your assets for long-term care and Medicaid down the road. Only an irrevocable trust protects your assets. So we have clients sometimes have revocable trusts. They come in to see us, and once they learn that it isn't protecting their assets, we can switch that to an irrevocable trust. We can work with the trust you have and amend it, or we can create a new trust for you. So it's, it can always be done in advance. If you meet with us, we review everything, and we can help you learn the difference between the two trusts and see what would be better about an irrevocable trust and what you can put into the trust. Now in here, I added something else that I hear a lot, and you don't have to be rich to set up a trust. A lot of clients start the meeting saying, I don't need, I'm not rich enough to have an estate plan, or I'm not rich enough to have a trust. And it's not just for that. It's for the middle class. It's for everybody. It's for you and for me. Most people put their house in a trust, and that may be all they do. Some people may have a little savings they put in the trust. But anyone can do a trust, and it can work in your situation. It doesn't have to be only if you're very wealthy. So if you want to learn more about trusts, come in and talk to us. We can go over why a trust would be good in your situation. Okay, next myth. We're going to get into some Medicaid myths here. And this one is pretty common, that Medicare, I even said it, Medicare is going to pay for my nursing home care. And it doesn't. So Medicare, which is your health insurance, does not pay for long-term nursing home stays or home care. What Medicare covers, it only covers rehabilitation in a nursing home after you've been in the hospital. So if you have a hospital stay, but you're not ready to go home yet, the hospital is going to tell you, okay, you can't send you home. We need to send you to a nursing home. So here's a list of nursing homes, and give us your top 5 nursing homes, and we're going to apply for them for you. Now that's, of course, really stressful on you, but on top of that, you have to figure out how you're going to pay for that nursing home. Well, the good thing is if you're going there for rehab, you have up to 100 days of Medicare to pay for it. In reality, you don't usually get up to 100 days. It's pretty rare. Usually somewhere around 20, 30 days is about when they say, okay, we don't think you need rehab anymore, and now you're going to have to pay privately. But while you're under the Medicare coverage, Medicare is paying in full for the first 20 days. And for the next 80 days, there's a copay of about $170 per day. If you have Medicare supplemental coverage, that is going to cover the copay. So generally, your Medicare stay can be free of charge to you. The hard decisions come when the Medicare ends, and they don't give you much time. They usually give you 1 or 2 days notice that the Medicare coverage is going to end. And then you have to either pay privately or get a Medicaid application in, or go home and so decide what to do. And that's when we get a lot of calls from clients, and we can help you through all of that. It doesn't matter if you haven't even done planning in advance, we can still help you do something at the last minute, help you figure out how you could pay privately and save most of your money. In an emergency situation like this, there's a plan where you can save half of your assets, and it's called a gift and a promissory note plan. So let's say you haven't done a trust, you haven't gifted away anything, you still have everything in your name, and you're in the nursing home and now you have to start to pay. So what we do at that last minute, or that crisis planning that we call it, is we gift away about half of your assets, and that gift is going to cause a penalty period, right? A certain number of months based on the dollar amount of money that you gift. And what you do with the other half of the money is you use that to pay the nursing home through the means of a promissory note. And by doing this, when all is said and done, you've gifted half of the money, you've saved half of the money, you've paid the nursing home through the penalty period, and when you get to the end of the penalty period, Medicaid is going to pick up and start paying. So that's a very, very brief overview of the process. What I would want you to remember is that even if it's a crisis in the last minute and you haven't done anything, you can protect your assets, and you should call us or an elder law attorney who knows what they're doing, who knows the Medicaid rules, who knows how to plan for this. In that situation, the nursing home isn't going to help you. Well, they're going to tell you, oh, okay, we can help you apply for Medicaid, but first you need to spend down all your assets. Then when you get down to no money, then we'll apply for Medicaid for you. So they're not going to proactively tell you, well, there's a way where you can save part of your money. And they're going to, push it on you, because there are people who work for the nursing home who will do the actual Medicaid application for you. You don't want to use those people, because they're just going to file the Medicaid app. They're not going to give you any advice about different ways that you can save money, whether it be the promissory note, whether it be some other way of exempting money. So that's something to keep in mind. If you're unfortunate and you're in that situation, please reach out and get some advice. The next Medicaid myth we're going to talk about is I have to lose my home and everything I own to qualify for Medicaid. Well, that's not true, because there is definitely ways you can keep money. So the spend down limit is $15,750 to qualify for Medicaid. So your assets have to be at that level before Medicaid will pay for you. But what people don't realize is there's a lot of exemptions that go into that. There's a spousal allowance that goes into that can let you keep more money. So you don't have to spend down until you have nothing. If you're married, your spouse can have about $74,000, and you can still qualify for Medicaid. So with a couple, you can keep about $90,000. That's money in the bank, stocks, investments. That's not counting assets that are exempt. So exemptions are your home. Now your home's only exempt if someone is still living there. But once you're, and not just someone, I'm sorry, let me back up. If your spouse or a disabled child is still living there, your home is exempt. The ones no one is living there anymore, your home is not exempt, and Medicaid puts a lien on your home. So home is kind of partially exempt, not fully exempt. So because of that, we always suggest that you protect your house by putting it in a trust. You don't want to risk it losing its exemption by not having a spouse or a disabled child live there and then have a Medicaid lien on it. The way Medicaid works with the lien is they give you Medicaid. Let's say you're in a nursing home, they're paying for you. They have a lien on your house, and the lien is going to be equal to the amount that Medicaid has paid out for your care. And then on your death, they're going to expect to be repaid. And depending on how long you've been in the nursing home, that could be equal to almost the whole value of the home. So to avoid that result, the only way to protect your house fully is to put it into a trust. The other big exemption that I'll talk about is retirement plans. So if you have an IRA or 401k or 403b because you work for a school or a hospital, those accounts are going to be exempt. The balance that you have in that account is not going to count towards that $15,000 limit. However, the income that you take from those accounts is going to count as your income. So that income, you're probably more used to hearing it being called required minimum distributions. Now, the rule up until this year was that you had to take your first RMD when you were 70 and a half. Now that has been pushed back to 72 when you have to start to take your RMDs. So here's an example. So let's say I'm 75 and I have a $100,000 IRA and I need to go to a nursing home. So that $75,000 is over $15,000, right? But it's not going to make me ineligible because it's a retirement plan. And as long as I take my required minimum distributions, that whole $75,000 is going to be exempt. Now, I still have to take my required minimum distributions every year, so that's drawing down on the account. But whatever is left in that account when I die goes to my beneficiaries with no Medicaid lien. It goes to them outright. So if you have a lot of your assets in retirement plans, like many of us do, those are automatically exempt for Medicaid. So that's a good thing. That's state by state, though. And I always like to point that out because that rule, a lot of the rules we talk about for Medicaid are federal and they're applied uniformly. But this one I know personally because I live in Massachusetts. Massachusetts does not exempt retirement plans. So if I had that money and I was in Mass when I'm applying, I'm going to have to liquidate that retirement plan, spend it down. So it's good if you're in New York where that's exempt. If you're thinking of retiring to a different state, it's always good to look at what the rules are going to be in the state that you retire to. The last thing for assets that are exempt are anything that you've put into an irrevocable trust. That protects those assets for Medicaid purposes. So you can have $15,000 in your checking account. You can have, $75,000 in savings in that trust. And as long as it's been in there the right amount of time, the right amount of time is either 5 years for a nursing home or 2.5 years for home care. If it's been in there for that amount of time, it's going to be protected. And what that means is after your death, the money in the trust goes to your beneficiaries. And again, without Medicaid having any claim against it, they can't put any lien against that trust money, and the trust money goes to your beneficiaries. Okay, so here's another one, Medicaid myth, that I can transfer my assets to my children and qualify for Medicaid. There's no special exemption for transfers to children or transfers to anyone for that matter. Any assets that you transfer within the look-back period are counted and can disqualify you for Medicaid. Generally, what the Medicaid offices are doing now is they're looking at any transaction over $2,000. And the way they do this, it's like an audit. When you apply for Medicaid, they're going to say, give us 5 years worth of your bank records, if it's a nursing home case. Right now for home care, you only have to apply with the current month's of financial statements. That's going to change, as we've talked about, on October 1st. You'll have to come up with 2.5 years worth of bank statements. And the Medicaid office looks through all of those statements, and they look for any withdrawal or check or anything of $2,000, and they need you to explain what it's for. And if you don't have a good explanation or it's a gift, they're going to count that. And what they do is they accumulate and they add up all the transfers that you have made during that period. And that's how they come up with a penalty period that disqualifies you for Medicaid. So some clients even say to me, well, what if I just take it all out as cash and stick it in the mattress, you know? They're going to see that, right? We're not going to see the money in the mattress. They're going to see that you withdrew $50,000 or however from your bank account, and they're going to know where that money went. And you can't really say with a straight face, I just went grocery shopping, you know, with $50,000. So it's all kind of based on what's reasonable and what isn't reasonable. Now, when you hire us to do a Medicaid application, our paralegals are great. They're very experienced. All 3 of them used to work at Department of Social Services and the Medicaid departments in different counties before they came here. So they've worked on the other side, and they see how Medicaid, you know, analyzes a case. So now they're working for you. So before anything goes to the Medicaid office as part of the application, they go through all the documents. They see everything that is questionable. We explain what all those withdrawals or transfers are for. If it is a gift and, you know, we can't explain it, then we come up with a penalty period and we try and figure out a way to offset that or see if the money can be gifted back. So that's what the benefit of having someone experienced do that application for you, is that we can look through all of your financial records and pick out what's going to be troublesome and help you figure out how to plan for that in advance. Here's another Medicaid myth I always hear, and this is that I can give away $15,000 per year under the Medicaid rules, or $10,000 or $12,000. The number's been different. You know, it was $10,000 for many, many years, and then it raised to $15,000 currently. And you can't. That rule about the $15,000, that's a tax rule. So for gift taxes, you can give up to $15,000 away per person and not have to file a gift tax return. However, if you give away that $15,000 and then you apply for Medicaid, that is still going to count against you. So as you can see, the federal government, one department doesn't always work with the other department. You know, the IRS is saying on the one side that this is exempt for a gift tax, but for Medicaid, you're still going to get penalized for making that gift. Now, while we're on the gift tax, I will just mention briefly that it's the threshold that you need to file a gift tax return, not to pay gift tax. The gift tax limit has been raised along with the estate tax limit so that not many people have to pay gift tax. You know, the exemption amount is about $11 million per person at the federal level. So what that means is over your lifetime, if you have gifted more than $11 million, then after that, you're going to have to start paying gift tax. When you do start paying gift tax, it could be about half the rate. You know, the rate, you're going to have to pay about 50% tax on every gift that you make. But that's not applying to most people. So it's just a threshold for filing a tax return. And you can file the gift tax return, report that you made the gift, and not pay any tax. So that's how it works on the tax side. On the Medicaid side, that is a transfer that would be counted against you. And you have to keep that in mind as you're thinking of applying for Medicaid, because if any of those gifts were done within the past 5 years, they are going to count against you. Okay. Next Medicaid myth here is that I can't, this is kind of the opposite. The first one was that I can give things away to my kids and I'm fine. This is kind of the other way. It's like, I can't give anything away. I can't give anything away and qualify for Medicaid. So even though generally anything you give away is counted, there are exceptions that you can take advantage of in giving things away. So any transfers before the look-back period are not counted. Any purchases are not counted. So you can't give money away, but Medicaid says you can spend money on yourself. So you can make an improvement to your house, you can go buy a new car, and that's not going to be counted against you if it was within the look-back period and if you have good receipts to prove all that. So that's important, is to make sure these things are documented, that there's some proof there of someone could figure out what this money was spent for. There's some, unfortunately, where someone has dementia and now the children are coming in to try and put together the financial picture for Medicaid. They may not be able to piece together what some of the money was spent for because their parent wasn't writing that down in a check register. They weren't keeping receipts. So that can be tricky. But if we have good proof of what the money was spent for, that's not going to count against you. Now, there are some true exemptions under the Medicaid law. So the first one is that any transfers between spouses are exempt. So that's if you have accounts that are not joint, that they're in your individual name. I could transfer them to my husband and that wouldn't be a penalty. We could transfer money back and forth to each other. And why would you do that? You would do that because if I'm the one applying for Medicaid, I can only have $15,000, but he can have more. He can have about $74,000. So I could take money out of my name and give it to him, so I become eligible for Medicaid. Another exemption is if you have a child that is disabled, they're receiving SSI or SSD, you can transfer money to them. And that money is an exempt transfer for you for Medicaid purposes. You can also transfer your house to a caregiver child. So lots of times an adult child may move back in with their mom or dad to take care of them. And if they've done that for at least 2 years, then the parent can transfer the house to that caregiver child, and that's an exempt transfer. So these things that are exempt, you can do them at any time. You can do them right before you apply for Medicaid, and it's not going to count against you. So there's exemptions that you can take advantage of. You may not know them yourself, but when you sit down to talk to an elder law attorney, they are going to ask you questions like this to see if there's any exemptions. And oftentimes I will just ask if any of your children are disabled, and not knowing the answer, and then sometimes you find that out, and that is a way to protect some of the money and to get it out of the parent's name to qualify them for Medicaid. All right, this myth is that once I'm in a nursing home, it's too late to do Medicaid planning. And that's not true. I spoke about this a bit before, that even if it's last minute, you still can do some planning. You can do the gift and the note where you save half of your money. And, this I kind of already touched on before. Let's see. Something I didn't touch on that is on here, another strategy you can use is to transfer assets to your spouse and do a spousal refusal. Now, couples who have been married for a long time usually look at me and say, that's horrible. I'm not going to refuse to take care of my spouse. It's really just a financial tool that you can use. You can put the assets in the spouse's name who's not applying for Medicaid. You can apply for Medicaid, and then the spouse that has all the money in their name signs a spousal refusal. It says, I'm not contributing any of my money towards the care of my spouse. Now, what really happens then is once you do that, the individual gets Medicaid. Now the county can turn around and come back after that spouse who did the refusal, and they can sue them or pursue an action to recover that money from them. But what happens is you can settle that case, you can agree to pay back the county. You're paying back the county at the county rate for the nursing home, which is different from what the private pay nursing home rate is. So right now, a private pay nursing home is about $15,000 a month. The county, once you're on Medicaid, what the county actually pays the nursing home is about half of that, maybe $7,000 per month. So if you're settling the spousal refusal case with the county, you're paying them $7,000 per month for the nursing home. So you're actually settling and paying less money than you would if you had gone and paid privately. So for certain clients in certain situations, that's a great tool that we can use to help you save money. And that's, you're getting the nursing home for about half the cost of what you would otherwise. Here's a myth that we hear all the time, that Medicaid will not pay for home care. We hear this all the time. We do our aging in place seminars, which is a great seminar to listen to when it's next available. And aging in place is staying at home and receiving care. And when we talk about this and we say that Medicaid will pay for it, everyone is surprised that Medicaid will pay for care at home. But they do. That's been around for a long time in New York. New York is one of the better states, believe it or not, to receive home care in. They have a very generous home care program. There's many different types of programs under the community Medicaid umbrella, but generally with all of them, you can stay at home, you can receive care, and Medicaid will pay for the home health aides to come to your house and take care of you. Now they do an assessment, they come out to see you, they see how many hours of care that you need. Once they approve you for a number of hours, you can go get the home health aides. You can either use the home health agency who will provide the aides for you, and then they staff the number of hours for you. Or you can use something called their consumer-directed program. And under the consumer-directed program, you go hire and find your own aides to work for you. So you can find neighbors, friends, it can be family members, to work for you, and they get paid by Medicaid. So that there's pros and cons to both. With the home health agency, you don't have to worry about someone calling in sick. The agency is responsible for all of the staffing. But on the consumer-directed side, you're picking who's going to be in the house with you every day, so you have more control over that. So community Medicaid, there's financial eligibility rules to qualify, just like there is for the nursing home Medicaid. It's the same dollar limits. It's $15,750 for an individual, $74,000 for your spouse if you're married. You can use a trust just like you can for the nursing home Medicaid to protect your assets. One difference with community Medicaid is that you get to keep your income and spend it. When you're in a nursing home, they take all of your income except for $50 a month. They put that $50 in an account at the nursing home, and you can use it to pay for little things that you need. It's not very generous. When you apply for community Medicaid, the dollar limit is $895 per month. And if you have more than $895 a month, you have something called a spend down. Now you don't lose that spend down. You can put that spend down into something called a pooled income trust every month. And you can use the money in the pooled income trust to pay for your expenses that allows you to live at home. If you have a home, it can pay your taxes, your insurance, your utilities. If you're renting, it can pay your rent. So there is a lot of flexibility. You can have two trusts. You can have one trust for your assets that makes you qualify for Medicaid, and then you can use the pooled income trust for your excess income. A pooled income trust is run by a nonprofit organization. It's not a trust that we set up for you with your children or someone else as the trustee, but the nonprofit organization runs it. they take your deposits every month and they pay your bills every month, and they're pretty easy to work with for a reasonable fee. And we give more detail about that in our Aging in Place seminar, which is going to be tomorrow. So if you want to learn more about that, we have another webinar tomorrow at 1 o'clock that you can go to find out more about community Medicaid. Okay, so I did say I was going to go over some of the questions at the end here. So I'm just going to take a look at the questions that we've received. And let's see, we have about 4 minutes left for the hour. And I will go through and answer your questions. Okay. So first one is, I have 2 children and I would like them both to be power of attorney over me. So that's a good question. When you have a power of attorney, you can name more than one person. You can name 2 people. You can have them act together, which is, I don't recommend as much as having them act separately. So you could have 2 kids and you could say one can act or the other could act. That helps if your kids live in different places, so they can, you know, each do business for you and help you out. All of our powers of attorney, whether you appoint 1 person or 2 person, we suggest that you have a backup in place. If you're going to go to the trouble of doing this document, let's put in 1 or 2 backups so you don't have to redo the document if that first person is no longer able to do it. Another question about powers of attorneys, I'll stick with this, is can a power of attorney be narrow in scope for specific transactions? So it can be, and we have done that. You know, for example, when I did the refinance for my husband, he could have done a power of attorney to me just specifically for a real estate transaction. You could do that to someone just to handle one particular financial transaction for you. That helps you in that situation, but we always recommend that you have a general power of attorney in case something happens to you that is going to cover more things than just that one transaction. You know, so you could do it narrowly just for one transaction for one person, but you should have a general power of attorney that covers everything. And another question, this is really good because this kind of gets into policy, and we hear this question all the time. What if you've given away all your money, right? And now you need to apply for Medicaid. This is a tough one. Let's say you need to go in a nursing home, but you've given away all your money, and now you have a penalty period. Well, first of all, these days, you're not going to get into a nursing home unless you have a Medicaid number, which means you've applied for Medicaid. So they're being very restrictive of who can get in and who can't get in, exactly because of this reason. Because once you're in the nursing home and you apply for Medicaid and you're denied, it's really hard for the nursing home to kick you out for not paying. It's not like an apartment where if you don't pay your rent, you can get evicted. If you're in a nursing home, they can't just evict you. It has to be what they call a safe discharge. They can't send you home unless you would have care at home, you know, or they could send you to another nursing home. So there's situations, I guess, sometimes where you're staying at home because you can't get the care in the nursing home, or you are in a nursing home and they're losing out on the money because they can't kick you out. So there really is no perfect solution to people who are in that situation. The best thing you can do, again, is to try and plan for this in advance so you're not falling under this situation. Let's see. So are there any disadvantages to putting your house in a trust? But there really aren't, because the way the trust works is that your trustees, even though they're in charge, you know, they're nominally in charge, the trust says that you have what they call a life estate. So that means you have the rights to live in that house for the rest of your life. Your trustees can't sell the house or kick you out, you know. They, if you want to sell the house, you can, but it has to be with your consent. So you're pretty much protected if your house is in a trust. If you trust, and the other thing to keep in mind is that if the trustees are not cooperating with you, let's say you wanted to sell the house and they didn't think you should, you still have the right to fire the trustees and appoint new trustees. So you do keep some control over that, about who the trustees are, so that you could ultimately control whether you stay in the house or whether you sell it. Let's see. Another question, and this I'll touch on, is gifts to charity. And this one always bothers me because Medicaid doesn't have an exception for gifts to charity. So if you gave gifts to your church or to your synagogue that were over $2,000, they're going to count against you as a Medicaid transfer and be part of that penalty period. And that's the way the law is now. That's the way it's always been. The only way to get around that is to apply for this exemption for gifts that were not for a Medicaid purpose. Let's see. There's some questions here, let's see, about long-term care insurance. I'll just briefly mention that. Long-term care insurance is another way to pay for a nursing home or for home care. It can be a good solution for you. The problem most people say is that it's too expensive, and that's why they don't purchase it. In fact, premiums have been going up in recent years because the cost of long-term care insurance, it's gone up because more people are claiming these benefits. That being said, depending on your income and your assets, it may make sense for you to do that. But for that, we always suggest you meet with someone who sells the insurance to go over your financial plan and see if there's a way to pay for that out of your own assets. Okay. All right, so we're just a little bit over 2 o'clock, so I'm going to end the webinar. But just to remind you, we have free consultation, so if there's anything you heard about during this webinar and you want more information that's specific to you, call us. You can call our office for a free consultation. You can email us. We can set up a phone call or a video call to talk to you and go over your questions. If it's creating a new plan, that's great. If you have an existing plan that you want us to look over, we can look over your existing plan and see if it needs any changes or updates. And another way that you can get more information is to listen to us on the radio. Every Saturday morning at 8 o'clock, we are on Magic 590 AM, and we, again, talk about these issues. We take in live questions from our callers, and that's another way to learn more about this topic. But we encourage you to give us a call, and we'll help you the best that we can. Thank you very much for listening. It's been great. Bye-bye.